July 27, 1934, Hughestown, Pennsylvania. Late at night, Harry Tompkins is walking home along a narrow, beaten pathfoot beside the local train tracks. A freight train belonging to the Erie Railroad Co passes him in the dark. According to Tompkins, something projecting from the moving train, an open boxcar door, strikes him from behind. He is knocked under the moving wheels. The accident severs his right arm. When Tompkins demands compensation, the Erie Railroad completely denies liability. 4 years later, on April 25, 1938, the United States Supreme Court would use this single, brutal accident to dismantle a legal doctrine that had organized the American federal courts for 96 years. The court executed that doctrine with a single 7-word sentence: "There is no federal general common law." This effectively dismantled the parallel legal system that had allowed federal judges to ignore local laws for nearly a century. It forced federal courts nationwide to stop inventing their own rules and start following the decisions of state judges. This diagram maps the parallel universe of the American legal system. Let's look at how a lawsuit is built across these lines. Tompkins lived in Pennsylvania, where the accident occurred, but strategically filed his lawsuit in a New York federal court. He used diversity jurisdiction, a constitutional mechanism allowing federal courts to hear cases between citizens of different states. In this case, a Pennsylvania citizen and a New York corporation. The original purpose was to protect out-of-state parties from local prejudice in state courts. The railroad argued that the federal court had to apply Pennsylvania state law. Under Pennsylvania law, established by its highest court, anyone walking on a longitudinal path beside the tracks was a trespasser. To a trespasser, the railroad owed almost no duty of care. Under Pennsylvania law, Tompkins would lose automatically. That Tompkins convinced the federal judge to ignore state law, arguing instead for general law, an unwritten national standard. Under this general law, the railroad owed him a duty of care, and the jury awarded Tompkins $30,000. Two completely different rules of law applied to the exact same physical plot of dirt in Pennsylvania. The victor was determined entirely by which courtroom door the plaintiff walked through. To see how this parallel legal system was created, we have to go back to the first Congress in 1789. They passed the Rules of Decision Act, which instructed that in trials at common law, federal courts must apply the laws of the several states. For 50 years, that instruction seemed clear. Then came Justice Joseph Story and an 1842 Supreme Court case called Swift v. Tyson. Story interpreted the 1789 statute in a highly specific way. He ruled that the word laws only meant state statutes, the physical texts passed by state legislatures. It did not include the unwritten, common law decisions made by local state judges. This created federal common law. Without a specific state statute, federal courts ignored local judges and invented their own rules. Story was highly motivated to make this interpretation. He believed in an august corpus of general commercial law, a single, elegant, overarching system that could unify a fractured and rapidly expanding American economy. By defining laws this way, Story handed federal judges the power to overrule local state judges on matters of general commercial dispute, allowing an independent federal legal universe to grow alongside the states. Over the next 96 years, Story's narrow ruling for commercial paper mutated. Federal courts expanded their general law power into torts, property rights, and local contracts. The absurdity of this expansion peaked in the 1928 black and white taxicab case. A Kentucky corporation wanted an exclusive contract to solicit passengers at a local railroad station, a local monopoly that was explicitly illegal under the common law of Kentucky. To bypass local law, the company dissolved itself, reincorporated in Tennessee, and sued its Kentucky rival in a federal court inside Kentucky. Through diversity jurisdiction, the Tennessee corporation accessed favorable federal general law, securing a monopoly that local citizens were forbidden to hold. This practice is known as forum shopping. Litigants manipulate their geography and corporate citizenship strictly to cherry-pick a more favorable legal system. The American dual sovereignty system had created a structural glitch. Out-of-state corporations were heavily incentivized to exploit the federal courts to defeat the local laws of the citizens they operated among. The intellectual rebellion against this system started in the dissenting opinion of that exact taxicab case. Justice Oliver Wendell Holmes Jr. launched a fierce philosophical attack on the majority's logic. Holmes argued that law is not a transcendent body floating outside of any particular state. To Holmes, law does not exist without some definite sovereign authority behind it. A federal court guessing at a general common law was just a court making things up. 5 years prior, Harvard legal historian Charles Warren had made an archival discovery that turned Holmes's philosophical grievance into hard historical evidence. Warren's 1923 article revealed the original 1789 Rules of Decision Act draft. It proved the authors explicitly required federal courts to follow statute law and the unwritten or common law of the states. They crossed the words out merely for condensation. Story was historically wrong. Warren's academic research armed the Supreme Court with the exact evidence they needed to kill the doctrine. They could finally ground the debate in the original, documented intent of the legislature, which brings us back to April 25, 1938. The Supreme Court seizes upon Harry Tompkins' railroad accident to finally execute the doctrine of Swift v. Tyson. Justice Louis D. Brandeis authored the majority opinion. He wielded Charles Warren's archival history and Holmes' legal philosophy to dismantle the old system. Brandeis's holding was absolute. Federal courts sitting in diversity jurisdiction must apply state law. It does not matter whether that law is declared by a state legislature or by a state Supreme Court. The era of an independent federal general common law is over. Looking at our legal matrix, Erie drew a hard new line between substantive and procedural law. Federal courts will now use state law to determine substantive rights, but will keep federal rules for managing the actual procedure inside the courtroom. Brandeis went further than necessary, declaring the old doctrine an unconstitutional assumption of powers. This fractured the court. Justice Reed concurred, but only on statutory grounds. Justices Butler and McReynolds dissented entirely. Justice Cardozo was absent due to illness. By framing the old doctrine as unconstitutional, Brandeis stripped the federal government of a power it had exercised since 1842, returning control over the common law to the individual states. In the decades following 1938, judges struggled to define exactly where a state's substantive law ends and federal courtroom procedure begins. Over time, the courts developed what is now called the twin aims of Erie, discouraging forum shopping and avoiding inequitable administration of laws. These were not Brandeis's words, but doctrinal shorthand invented later to help judges navigate. This diagram shows how unique the American system is. In other federalist nations like Canada or Australia, a single national Supreme Court ensures a uniform common law across the country. Erie permanently cemented a fractured state-by-state reality for the United States. As for Harry Tompkins, his personal story ended quietly. Following the Supreme Court's decision, his case was remanded to the lower courts to be judged strictly under Pennsylvania state law. Deemed a trespasser, his initial $30,000 victory was completely erased. He received absolutely nothing for his lost arm. Tompkins paid the ultimate financial price, but his tragedy reorganized the American legal system, cementing the reality that law cannot exist as an abstract ideal. It must always